Are you the parent, sibling, spouse, or concerned friend of someone with mental health issues? You desperately want to get help for them, but don't know exactly what to do? Then you need to watch this video. Hi, I'm Antoinette Bone, estate planning, probate, guardianship, and elder law attorney in the Dallas-Fort Worth Metroplex. Today I'm going to talk to you about guardianship versus mental health commitments. This video is a part of a series on guardianship, so if you haven't seen my other videos, be sure to take a look at my YouTube page. I've gotten calls typically from a parent wanting to know what they need to do to get guardianship over their adult child with mental health issues, or how can they get their child committed to a psychiatric hospital. They've called because they are frustrated that law enforcement won't do anything to help them. They want to get their family member help, but the person will not willingly seek treatment. So first they want to know how the person can be committed, and then they want to know if guardianship is a viable option. So let's start off talking about mental health treatment. Different statutes address mental health and guardianship. The Health and Safety Code, commonly known as the Mental Health Code, addresses mental health, and the Estates Code addresses guardianship. There are significant differences in the procedures for each. The result of the imposition of a guardianship or a mental health commitment, though, can look very similar. The difference is in the legal definitions for the determination of incapacity in a guardianship and the criteria for commitment in the mental health arena. There's also a difference in how each process can be started. When it comes to mental health commitments, law enforcement is involved. This is not typical in guardianship proceedings. If the person you are concerned about has a chemical dependency, such as alcohol or drugs, you need to know that in the state of Texas, involuntary commitment for treatment of these issues is almost non-existent. The Texas Constitution prohibits the commitment of a person because of unsound mind, except on competent medical or psychiatric testimony. The law does not give a third person the right to admit or treat a person, even on a voluntary basis, in an inpatient mental health facility. Only the person being treated in an inpatient mental health facility can agree to voluntary treatment. Generally, in order to have someone involuntarily committed, it must be shown that there is a serious, clear risk of imminent harm to the person or to others. Like guardianship, involuntary mental health treatment is a serious matter, and the law treats it as such, because civil commitment can constitute a substantial denial of basic human and constitutional rights without the person having violated the law. So what does that look like in real life? A person alleged to need mental health treatment can be detained without bond for up to 30 days pending a final determination of the veracity of the allegations in an order for protective custody. In order to protect people from having their civil rights violated without cause, the law has in place strict procedures to follow. Although the commitment process is civil in nature, violation of the rules of the process can lead to criminal penalties. The involuntary commitment process can be broken down into three parts: emergency detention, protective custody, and commitment. Understanding the difference between these three concepts is crucial. Most of the involuntary commitment cases are initiated by an emergency detention. This procedure can be done with or without a warrant. The peace officer seeking to detain someone without a warrant must have sufficient reason to believe that the person has a mental health illness, and that because of such illness, there is a substantial risk of harm to self or others that requires immediate restraint. The person being detained must be informed of the basis of the detention by the officer and must be informed of their rights in the facility within 24 hours of admission. Any adult may file an application for emergency detention of another. If the application is granted, a warrant is issued. This process isn't necessarily any easier. For a court to issue a warrant, it must be shown that there is credible and adequate information that warrants the person's detention. The purpose of the issuance of the warrant is to ensure the rights of the proposed detainee or others if there is a substantial imminent risk of serious harm. The applicant will likely have to testify in court as to the facts and circumstances necessitating the issuance of the warrant and subsequent detention. Now, even if issued, the person being detained may be only held for 48 hours. They must then be released. Typically, when a distraught family member or friend contacts authorities for help in dealing with someone with mental illness, they request an order of protective custody. But this is not the correct remedy to request. An order of protective custody is something that is issued only after the detained person has been examined by a physician. The physician must state the person detained is someone with a mental illness and presents a substantial risk of serious harm to themselves or others if not immediately restrained. Inpatient and outpatient mental health services differ. Thus, they each have their own requirements as to what must be proven. Under the Mental Health Code, in order for inpatient commitment to happen, the proposed patient must be a person with mental illness, and as a result, the proposed patient is likely to cause serious harm to himself, or the proposed patient is likely to cause serious harm to others, or the proposed patient is suffering severe and abnormal mental, emotional, or physical distress and is experiencing substantial mental or physical deterioration of the proposed patient's ability to function independently, which is exhibited by the patient's inability, except for reasons of indigence, to provide for their own basic needs, including food, clothing, health, or safety, and they are unable to make rational and informed decisions as to whether to submit to treatment. Outpatient commitments are for people who have a severe and persistent mental illness that would result in a deterioration of the ability to function independently without a court order requiring them to participate in treatment. For this type of commitment, a court may order a proposed patient to receive temporary or extended outpatient mental health services if the judge finds that appropriate services are available to the patient and the judge or jury finds the proposed patient is a person with a mental illness and the nature of the mental illness is severe and persistent, and as a result, the proposed patient will, if not treated, suffer severe and abnormal mental, emotional, or physical distress and will experience deterioration of the ability to function independently to the extent that the patient will be unable to live safely in the community without court-ordered outpatient services. And the patient has an inability to participate in outpatient treatment services effectively and voluntarily. Mental health commitment is an involved process requiring the involvement of a physician, law enforcement, and due process. It is not as simple as calling the police and telling them your aunt, neighbor, sister, or brother needs to be committed because they're acting crazy. Understand, what the police can do is limited by what the law says about the circumstances in which emergency detention is warranted. If you have a family member or friend that needs help, contact a probate, guardianship, or elder law attorney to discuss the best way to proceed. I'm Antoinette Bone, estate planning, probate, guardianship, and elder law attorney in the Dallas-Fort Worth Metroplex. If you found this content useful and would like to see more like it, please subscribe to my page, like this video, and don't forget to tell your family and friends. Thanks for watching.